impression of your lordship's demeanour and
Can
displayed.
you ask my recusal, Mr. Breda?
I'm sorry,
Can you ask for my recusal?
no, I'm not. I'm busy addressing your lordship.
Yes,
Placing on
you
record
can't
what my
address my
instructions are.
demeanour at this stage of the time.
Sorry, Lord.
You can't address my demeanour at this stage of the time. That you can do at the end of the case.
No, with respect, Lord, my client has got a concern at this stage, and with respect, I, as his spokesperson, needs to be able to place that on record. With respect,
So what are you placing on record?
I'm attempting to do so again, Lord.
But can you do this at this stage? Or should you not wait till the end of the
No,
trial?
with respect, Lord, my client is concerned at this stage in which the manner in which your lordship specifically is questioning this witness. This is not the first time he said, your lordship is dealing with the
Mr. Botha,
cross-examination.
you're an old hand at this. You know that the court is entitled to clarify any issue which a witness makes. It's my function to speed up this trial if I can.
Absolutely. But my
If
Lord,
the
that's
witness
not
is
my...
being dilatory, I can bring her on pause.
May I address your lordship on this?
Yes.
My client's concern is not the fact that your worship is asking, putting questions to the witness. My client's concern is the manner in which your lordship is putting, and clearly displaying respect, a certain degree of irritation with the witness.
Irritation.
Yes, Lord. That is the impression that is created at this stage with my client. He says your lordship's tone of voice differs vastly from the manner in which your lordship questioned witnesses from the state, testified on behalf of the state. Your lordship's voice intonation displays, again, a certain degree of impatience at least toward the witness, and he's concerned about it. With respect, I'm entitled to, in fact, I'm duty bound to place that.
At which section of the law of evidence or the law of criminal procedure can you raise such concerns in the middle of a trial? Where have you heard this before?
My Lord, with respect,
We've been in the criminal courts for years.
I know, but
Have you ever seen somebody stand up and say, my lord, my client is concerned by your impatience? You can take that point on appeal if you may wish,
my Lord, but the record,
or any other forum.
the record would not show your lordship's a tone of voice or intonation of speech. With respect, it doesn't.
So,
It's words that we read on paper. And my client, with respect, if he is concerned and he addresses me on that, and with respect, this is not the first time today that he's voiced that. He's not done it again. I need to take instruction. I need to do my work with respect.
you need to do your work, but you can observe the norms and practices of our court. If you don't like the tone of voice of a judge, what can you do?
Lord, with respect, may I just make myself again clear?
Yeah.
It is not I who am saying that. I'm addressing your lordship as to what my client is perceiving at this stage.
Yes, but even then, in every case, the clients don't like the judge. So can you stand up in the middle of
with respect,
cross-examination and
that's not what I
say,
That's not what I place on record. I never place on record my client doesn't like your lordship. I place on record my client is concerned about the manner in which your lordship is questioning my witness.
yes, but I have been endeavouring to speed up this witness to get to the point she's making, rather than intimidating her, or what's the word you use? Tone of voice, impatience. Perhaps I've displayed some impatience. That's hardly a cardinal sin.
I'm not also suggesting it's a cardinal sin. It is, in the end of the day, it's about the impression of my client, the greatness of my client, and we all know the old saying of judgment must not only be done, it must be seen to be done. And whether your lordship, and I'm not at this stage, with respect, I'm not at all suggesting that this is an application of your lordship's recusals. I'm not even going there. I'm just placing on record that my client's concerned about that, and he asked me to place it on record.
Can I just note your client's concerns? The client's concerns are noted. Ms. Galloway, you need not address me. Please carry on with the cross-examination.
Dr. August, with regards to your evidence on the maintenance record or maintaining of the equipment in the laboratory, although you say you've got no evidence or no information to the contrary, you are not willing to accept the evidence of Colonel Otto, who testified and said it is done and it is maintained properly.
My Lord, I will give the shortest possible answer that I can, without seeing any evidence and seeing that she testified under oath. I have to accept her at her word, and therefore I received no evidence to the contrary.
So then you accept that evidence that it is done Correct.
What's your answer to that?
I accept her at her word.
Like you want the court to accept you on your word when you testify about how your laboratory works. Because nobody accredits you, you have no proficiency, you just testify as you see fit.
My Lord, I don't testify as I see fit. I testify according to the objective assessment that I made of the data that was given to me. And my Lord, if I may address an issue that came up earlier today about the report, I've realized during lunch that Your Lordship had asked me, had I compiled an independent report? It was not called a report. I compiled an audit document for myself. That was an independent document that I compiled. It was not intended to be handed into court or anything, but that is from which I compiled my report. So given that...
I went to ask you independent report is the first, when you first had view of all the evidence, did not immediately report to your attorneys, okay, this is my view, this thing is flawed in 10 respects or 100 respects. You never did such an independent report at the beginning.
I did not do a report, no.
You see, the reason for that is simply this. If you did the report only after you heard evidence, that means your whole vision of this matter, the scientific vision, was clouded by the evidence, your consultations. I'm not saying your counsel told you what to say, but you were in consultations, you did hear evidence, you did hear the cross-examination of the other witnesses. So your report is a product compiled after all that. That's
yes,
all.
my Lord. I only wanted to correct my statement of earlier this morning.
So am I correct?
Correct.
Yeah. Okay, so now what do you want to say?
So I only wanted to correct my statement of earlier this morning when my Lordship asked whether there was a report, and I understood it to be a formal report like this. There was not, but there was my audit document.
But that wasn't made available to the state.
No, it was an internal audit compilation of the audit information that I did.
Now moving on to the next aspect that wasn't disputed in cross-examination with the law author. She testified that competency and proficiency tests are done in the laboratory. And it is a singular test that is used worldwide, not just in South Africa, to test the proficiency and competency of all the analysts and the people inside the laboratory.
That's correct, my Lord.
Now, leaving aside Colonel Otto's proficiency, of which you pointed out your views on, the rest of the analysts, their proficiency, their training, their competency, all of that form part of your paper trail that you requested before the trial started. Is that correct?
Correct, my Lord.
And that was given to you as part of the paper trail.
My Lord, as far as I can recall from these almost 2,000 pages I got, yes, we did receive that.
So apart from Colonel Otto, it is not your case or the defense case that the analysts or the other people involved in the laboratory are not competent and were not proficient to do their work.
My Lord, the CTS test that was offered for Lieutenant Colonel Otto's proficiency, obviously that test affected more than just her, so everybody who worked on that process. And we have, when the scope was narrowed to that particular proficiency test.
So you said that repeatedly, the scope was narrowed.
Yes, my Lord.
What do you mean by that?
So in the beginning, of the 151 samples, there were mixtures and single profiles. So we divided them into sets A and B, given the amount of resources it would take to work through all 151 samples. So we divided it into sets A and B. Set A, if I recall, and I can verify that, but one of them we requested extensive documents on. So for each of the processes, for instance, but for the other set, we requested only the sample status reports and the electropherograms. So for 35 samples, we requested the entire paper trail. And for 81 samples, set B, so there were 35 samples in set A. We requested the entire paper trail. In sample set B, there was 81 samples, and there we requested the electropherograms, so the EPGs, and the sample status reports. Those were the samples that, when I speak about the scope, was narrowed because we did not request all the data for all the samples. It is just a volume of
samples. If you
samples.
had all the samples, would that made any difference to your conclusions?
My Lord, I cannot say. I can only talk about what we did see.
And those you pointed out via cross-examination of Colonel Otto, is that correct?
My Lord, these samples were 116. Subsequent to that, we became aware via counsel of two subsequent affidavits by Lieutenant Colonel Otto. Those samples were divided into sets C and D, and I am trying to quickly find the numbers of sets in C and D, which I can provide to the court tomorrow. But again, I believe they were split into a set where we requested all of the data and a set where we requested only the electropherograms and the sample status reports. But
So what you requested you got?
So in total, we received 151.
So what you requested you got? Is it?
My Lord, we did not receive all of the SOPs, and I will make that count tonight because I didn't have time during lunch. And to my knowledge, and I will verify that also tonight, to my knowledge, we did receive the rest that we requested. Except for the document, except for documents such as documents where we asked, for instance, for the hemastix photographs and so, that we did not get. But as far as I know, and I can confirm that tonight, we received what we asked for.
You told your counsel to ask. We told your counsel to ask those missing items as well.
Correct.
Now, Dr. Corpus, coming back to my question, is it your evidence that because of the reporting officers' incorrect reporting, all the analysts are also not proficient?
My Lord, the proficiency tests, how they are conducted is a laboratory.
Corpus, I don't want to interrupt you. I understand, and I'm quite sure the court understands the concept of the proficiency test. I'm asking you a very specific question. Is it your evidence that because the reporting officer reported incorrectly, the whole process, all the analysts, everyone who works in the laboratory is not proficient or competent? Is that your evidence?
My Lord, if the proficiency test is failed or the wrong answer is given, everybody that participated in that proficiency test, their proficiency certificates cannot rely upon that incorrect answer that was provided. Because the reason the answer was incorrect actually happened downstream, and I can explain that.
So your evidence that all these results they must be rejected? Or not?
Of the analysts, so all the analysts who participated in that CTS proficiency test, their proficiencies should not rely or be based on that proficiency test outcome. If they had done other proficiency tests that we have not seen, then they could be proficient, but based on this one, they are not proficient.
And you're not saying that the laboratory did not get an answer. We deal with that specific error or fault that you pointed out. It is not your evidence that the laboratory did not get you answer in the analysis of that proficiency test. Your testimony is, if I understand you correctly, because they got it wrong, they're not proficient.
Correct.
We'll deal with that later. You have already confirmed...
Sorry, does it happen frequently that these tests are wrong? I mean, they did in such a big case, they must be doing in every other case as well.
My Lord, I hesitate to go to other cases. I will have to go and literally verify. But this is a case with more samples than I've ever seen.
This case had more samples.
This case had more samples.
But, okay, carry on, Ms. Governor, we'll deal with that.
Dr. August, you have confirmed in your evidence in chief the principle of the low-part exchange principle, the exchange of physical materials from a scene on a person or a person on a scene. It's a two-way process, correct?
Yes, my Lord. The low-part principle states every contact leaves a trace.
This is indeed a normal scientific principle which just finds a particular application in forensic science.
Correct.
Your evidence in chief, you also mentioned something, Dr. August, that you regard touch or epithelial DNA of a second or a weaker nature than other DNA.
My Lord, what I testified was that the amount of DNA, of touch DNA, is lower than in a regular sample, because if I touch the bench, even my fingerprint leaves behind. So even that would be measurable DNA that is left behind, which is obviously much less than were a blood sample taken from me, for instance.
And blood also, it's more difficult to remove blood, given low-parts principle. If blood is to be transferred to a scene, it's more difficult to remove blood from a scene than epithelial DNA, epithelial cell. Do you agree?
My Lord, I have not done experiments to that effect, and if there's a lot of blood, if the blood is more than the epithelial cells, the blood will actually be removed.
You're not prepared to answer that question?
No, I am answering the question, my Lord. And I understand that my Lord is just trying to clarify it. What I'm answering to the state is that if there is much more blood than epithelial cells on a scene, it stands to reason that if these are deposited on top of each other, so there's first touch DNA and then blood on top, then the blood will be removed first. So perhaps I didn't...
Maybe I didn't word my question correctly, Dr. August. Not blood and epithelial over or cross each other, separate. It will be easier for epithelials or other form of DNA to be removed from a scene than blood.
My Lord, I cannot tell whether that would be the case or not.
So when Colonel Otto testified and said it is her inference, because of that experience, that blood is more difficult to remove or doesn't dilute as quickly or gets removed from the scene as quickly as other types of DNA, that it is her inference that the sample, for example, in the shower was blood, not another form of DNA. Am I making myself clear? I see you frowning and it's taking a while. I'm making my question clear.
My Lord, I'm trying to recall what Lieutenant Colonel Otto said. So if I understand correctly, and perhaps the question can be repeated to me so that I may...
Let me put it to you this way. Although blood is also water-based, there are other properties to it. For instance, proteins, the iron, which makes it react to luminol or blue star, and a lot of other non-polar substances that are contained within blood. Non-polar, P-O-L-A-R.
Oh, non-polar.
Which are contained in blood, which causes it to be more difficult to remove. That is why there is something like blue star and luminol.
My Lord, it's not the iron that will make it more difficult to remove. How easy or difficult blood is to remove from the tiles in the shower, I will not be able to tell. And whether it's easier to remove that from than epithelial cells, it would depend on many, many aspects, such as what the tiles are coated with, etc. I cannot say at this. I cannot say.
Are you willing to accept Colonel Otto's inference from her experience working with blood or not?
My Lord, I'm again asked to accept something that another expert said under oath. I have no experience in that regard, so I cannot say. I can only take her at her word. I have no experience to counter that. Since I'm not a blood spatter expert or...
So for me now, then we get to the actual DNA process, which you quite conveniently set out in your exhibit E1, your diagram of the whole process. And I'm putting this to you now.
Which one is that?
E1, Lord, the, for lack of a better description, the flow diagram with the blocks.
Okay.
And please understand, Dr. Walton, I'm not trying to sound clever or anything. I just want to make sure I understand DNA the same as you understand DNA. I know I will never know it as well. I'm just trying to understand it. Okay? So, as I understand the whole concept of why DNA can be used in criminal matters or to determine some form of identity or probabilities, is that you start with the fact that every cell has a nucleus. Correct? I'm sorry.
Every spatter has a?
Each cell has a nucleus.
Oh, each cell. Okay.
Am I correct, Dr. Walters? I don't want to do the whole thing and then...
My Lord, each cell that, not all cells in the body has nuclei, but most cells do have. Immature red cells, for instance, does not. Immature red cells have, but mature red cells does not, and so on. But the white cells that we work with when we extract DNA, those do have nucleus, and muscle halves, etc.
Now we go inside this nucleus. There are what is called coiled rods, which are made up of chromosomes. Am I correct?
My Lord, if I may assist in handing out yet another page to just illustrate, because I'm going to use this jargon now. And it's a page of the 46 chromosomes that is in a cell, and I cannot, it's not a coiled rod, so each cell, I apologize, my Lord. Each cell has 46 chromosomes, 23 of which we receive from our fathers and 23 from our mothers. And on that is what we call the genetic material that is within the nucleus. And on those chromosomes are the markers that are used in forensics. So, my Lord, I don't have the handout with me. It's actually in a folder that's in front of my colleague.
So I think we'll help you. What should we mark it? Z, C.
My Lord, may I just clarify? It's triple E9. Correct, my lord. Just a clarification. So, my lord, on this page I've tried to indicate in red the chromosomes that we would have inherited from our mothers, and then the blue indicates chromosomes inherited from the father. And since this depiction has an X and a Y, it would be for a male chromosome. And so there's 46 chromosomes, and then the DNA markers that are used to compile these DNA profiles, when we look at D13, for instance, on chromosome 13, there would be D13S317. And if we now compare that to the tables in the affidavits on exhibit ZZ2B, that would be the D3 locus that is mentioned right on the left-hand side of all the STR loci. That's the only thing I wanted to make clear.
So what's the point of this document?
So this is just to point out that there are 46 chromosomes in the cell. The state asked me about the coiled rods.
Yes, because that's not an issue.
No, Lord, I'm just trying to
Get to the point.
ascertain from the witness whether I understand DNA correctly. I was getting to the 46 chromosomes.
But she's helped, you should volunteer the information.
So, Dr. Walters, now, as I understand the DNA as well, we have the 46 pairs of chromosomes, which contain coding and non-coding regions. Is that correct?
My lord, there's 23 pairs of chromosomes, so in total 46.
Chromosomes.
Correct? 46, and there's coding and non-coding, correct?
And as I understand it, the coding regions contain information which are necessary to create protein, and they are known as genes. Correct?
Correct, my lord.
And the coding regions is about, from the literature that I read, forms about 95 to 99% of the sequences of the chromosomes. And they are identical for all people in the sense that you have hands, you have ears, you have feet, you have legs.
My lord, there is a lot of DNA that is non-coding, but yes, there's a lot of genes in the 3 billion base pairs that we have. So I agree with the state that there's a lot of coding and non-coding DNA. I believe that was the question.
And it is, as if I understand the literature correct, Dr. August, it's the non-coding parts that contain the polymorphic DNA markers, which differ from individual to individual.
My lord, some of the markers that are used in forensic science, for instance VWA, is actually part of a coding gene, etc. But yes, they are polymorphic. So polymorphic just means that there are many alleles at each of these loci within the population. So for instance, at D3 there may be, I forget what the number is, but there may be many alleles, and each of us have 2 copies of those alleles. So the markers that are used, yes, they are polymorphic.
And it is these polymorphic markers that is used in the STR process of DNA, the short tandem repeats.
Correct.
The STR is exactly what it says. It's short stretches of polymorphic DNA, which are then repeated many times.
Correct, my lord.
Short tandem repeats, my lord. It is short stretches of polymorphic DNA repeated many times.
Okay.
And it is the variability in these repeats that is what is used to ID a person in terms of STR.
My lord, yes, it's the variability in the repeat lengths that we use, but it doesn't speak to identity, it speaks to the probabilities.
And this is possible because, as I understand it, the exact location of a gene or polymorphic marker is known. This is what you call a loci or a locus.
Correct. The exact
and
location.
it will be there on that same spot in each of the chromosomes of that specific person.
Correct. It will be, as we look at the 46 chromosomes here, they are present, these markers are present in all of us.
It's different.
Except My Lord, I have to correct, except that we are not all male in the courtroom.
And it's the different variations of these genes or loci.
Gladly
that are
so,
known
yes,
as
Dr.
autism.
Alkes. Gladly so.
I agree, Your Lordship.
And it is the different variations of these genes or loci that are known as alleles.
Correct.
And where an allele is at a very specific locus, that is called your genotype.
Correct, my Lord. If I may refer to ZZZ2B, that's exactly what I pointed out there. So for the 1014 genotype at locus D8, which is indicated in red.
And if we then go back and we have a combination of the several genotypes from multiple loci, that is the DNA profile of an individual, such as what you here have on exhibit EE9. This is a DNA profile.
My Lord, this is triple A9.
Triple E9 is
Triple
the
E9
figure 2.4. That's triple E.
is the chromosomes that are present in us all on ZZZ2B, where I've indicated it in purple. That is what we would call it a DNA profile. So the combination of all the genotypes at all the loci, plus the genotype at the amelogenin, so the gender marker.
Now, it is only once the individual's DNA profile is obtained that it can be used to determine or compare with the sample found on a crime scene or the suspect, or whatever the case may be. The profile is compared.
Correct, my Lord.
So, and the profile of a person, as you testified, it's a combination of several genotypes from the multiple loci.
Correct.
And if I can use the example of the DNA is similar to somebody's telephone number. All of us, if you ignore the area code or the service provider number with cell phone numbers, everybody's cell phone number consists of 7 numbers made up out of the 10 digits in our numerical system. And it's the order in which they follow each other in the number which causes you to make contact with the person you want to talk to. Would that be a very simplified example of DNA?
My Lord, I would not agree with that statement for the following reason. A cell phone number is unique to each of us, whereas the DNA profile that the state is referring to is based on 9 STRs, and that may not be unique to a specific individual. There has been cases in the world where people have matched on 9 STRs, and then when more were typed, they no longer matched. So I understand the analogy, but it's not an issue of identity. It is just your cell phone, you can be reached with your cell phone. So if you type sufficient number of markers, yes, you will be able to get to a specific individual in time. The analogy when we are just talking about 9 STR, yes, it is incorrect. So what is incorrect about the analogy is that when you call my cell phone number, you will only reach me. There have been cases in the world where 9 STR profiles, so profiles such as these that were submitted to court, were found to match between unrelated individuals. So if you type sufficient number of STRs, then yes, you will be.
Wouldn't that be a very unlikely event for the 9 STRs?
My Lord, and unlikely as it might be, it has happened multiple. It has. There were databases where it was searched in the 60,000 odd entries in the database, and there was. My Lord, I will have to make that calculation.
Dr. Alkes, is that part of the incident in America where it was the database from the prison system was used and they haven't fully figured out how these people had the same DNA? They speculate also that it could also have been the same person who was at some point in time incarcerated under 2 different names.
My Lord, no, there are several reports in the literature. I do not have them with me. where it was found that 9 SDRs are not sufficient, which is why the world, even at 2015, when we look at the CTS test that the FSL completed, most laboratories who send in that CTS test used 15 or more SDRs profiles.
We'll deal with that
Yes,
a bit
15.
later on again, Dr. Olbers. Leaving aside the merits or demerits of using 10 alleles as the lab did in 2015, do you agree that as far as DNA is concerned, it is the profile of a person, the whole profile that needs to be present for that person to be read into a sample?
Correct, my lord. Leaving aside for the moment how many SDRs needs to be in the profile, the entire profile needs to be present, correct.
Could you tell us tomorrow how many cases there are, maybe 9 SDRs matched?
My lord, I will do my utmost to find
Okay, fine, so
those.
Do I understand the DNA process correct, Dr. Olbers, that the gene mapper, there's a lot of using of that word, the gene mapper is the operative part of the DNA process? That is where the sample after quantification and amplification is fed into this machine, who then measures the location, the height, and the base width of each allele.
My lord, that's how I understand it.
And it is because this process of the gene mapper that is, as I understand it, very sensitive. It will also see or pick up what you refer to as stutter, which is usually on the left of the allele.
My lord, yes, that is true. The gene mapper is a software program that is programmed according to specific parameters to pick up, for instance, artifact peaks like stutter and so on.
Shoulder stutters, non-true alleles. As you quoted from Butler's book, Heineken exhibit triple E6.
Correct, my lord. Whether all of those are entered into the FSL gene mapper, that can change. They can add or
And
not with all
as
of
I
That means
understand,
that
Butler, I don't know
the
what he said, it's titled in the doctor professor. But as I understand his caution in exhibit triple E6, one has to be very careful in how you read or interpret what is picked up, so to speak, by gene mappers, because it can be misinterpreted.
That's correct, my lord. That's also how I understood it.
And all of this that I've now put to you, Dr. Olbers, is generally accepted scientific techniques of science used in DNA principles in the world, in the whole world.
Yes, my lord. Most laboratories don't use the 9 STR locus kit, but for the principle alone, this is the profiling process that is used.
So that in short,
My lord, I apologize. There was a part of the question that I now realize that I didn't catch of the previous question.
Can you have your previous question? Perhaps your
that one
junior
must,
could assist you, Ms. Galloway.
that the court must, that one must be very careful when you interpret the alleles, the stutter, the shoulder stutter, the artifact, whatever the name might be. One must be very careful when you interpret whatever is given to you, the data by the gene mapper.
Yes, my lord, I apologize. It was the question after that. The whole world uses.
You have the record to play back?
It's a scientific process, Dr. Olbers. My
Yes.
question was, it's a generally accepted scientific technique of science in DNA practices that is used in the world.
Yes. So,
It's
my
not
lord,
like the FSL is using another process than the rest of the world.
my lord, the FSL is using the same process but with less STR markers than most of the world
We
uses.
will get to the STR markers, Dr. Olbers. Now, given your evidence that you are testing the laboratory against the SOPs, do I understand your opinion to be that the purpose of the SOPs is to limit the risk of contamination of these samples whilst they go through the whole scientific process, and to ensure that you get true, reliable, or acceptable results.
Yes, my lord, there's one SOP that speaks specifically to contamination, but the set of SOPs is there to ensure that valid scientific results are generated.
If I may be very simplistic again, Dr. Olkers, if I were to bake a cake, a specific type of cake, I have a recipe and I need to follow the recipe to get that specific type of cake. Similar to SOPs. If you want to do a DNA analysis, you have to follow the SOPs to get the DNA result.
Yes, my lord, but only looking at the result is not sufficient, but we will...
Dr. Olkers, I don't want to interrupt you.
Yes, my lord.
I don't know about that analogy, Dr. Olkers. I'm not quite sure what the result would be if the cake flops.
My lord, I must say, neither am I.
Yeah.
But yes, if you take a specific protocol and you execute that protocol step for step, then you would end up at the desired end result.
Do you also agree, in terms of the SOPs, of the FSL, that the analysts in the laboratory, they work blindly from the submission stage onwards?
My lord, I am not sure about that, because often we would see a sample status report or another report where it will be written urgent, or the name of the case will be there. So I can't say that it is totally blind. It should be blind.
In general.
In general, it should be blind.
And samples are processed in batches. And these batches are randomly determined by the STAR Lab software program. Is that correct?
Yes, my lord.
And as I understand the process, batches are in the laboratory in the FSL, they use tubes which are placed in these racks as per the computer-generated work list, and the tubes are verified against the barcode of each tube by the analyst.
My lord, the batch consists of X number, and the process should work in such a way, I agree, that the barcodes are verified, and that the program is the program that puts the samples in a row or in a specific batch, ensures that the right sample is placed in the right position in the right batch.
And you have one analyst who works per work list, per batch.
I would presume so, my lord.
And these samples are then kept in a tamper-proof bag in a limited access fridge, where an analyst must ask for and sign for all the samples he or she works with. They are not allowed to go into the fridge and fetch what they want. They move to a certain point and ask the person who is responsible for that fridge, I need this and this list. You are given the list and you sign for it.
My lord, I would presume that is how it is happening, because other than in other countries where defense experts are invited into laboratories to see how the laboratory operates, South Africa does not have that system in place. So I've not been inside their lab to see exactly how they do it, but from the paper trail that we discover, it seems like they have to sign it into a fridge, and then somebody else signs it out of a fridge.
You don't dispute what is being said?
I have no evidence to the contrary, my lord, no.
So you can't dispute what is being said?
I don't have evidence to dispute it, yeah, correct.
And that the different analysts don't have access to different fridges in different areas of the laboratory. You work in a certain area and that is, you have only access to those samples?
I would presume so, my lord.
If I'm not mistaken, the next stage is the isolation stage, where the liquid is added to the sample and it is centrifuged. And this is where the DNA is extracted from the initial sample that was taken. Is that correct?
Correct, my lord. It's centrifuged and then the DNA is isolated, usually with a specific kit.
And this is then where the qPCR comes into play.
Right, my lord, right after isolation, qPCR would be done to verify how much DNA is present in a sample.
And whether it is indeed DNA, human DNA.
Correct.
And it also determines what gender the sample is, male or female.
Yes, my lord, the machine indicates that, and so it measures human DNA and male DNA and calculates the female component by subtracting the male from the female component.
And this qPCR process is again done similar to the isolation process, where a new batch list is created by StarLab program, the new analysts work with it, and they follow the same procedure.
My lord,
to the PCR unit.
my lord, that is how I understand it from the paper trail that we discovered.
It is only once the sample has gone through the whole qPCR process that you now have an actual DNA sample that you can use to make any kind of determination, to determine a profile.
Yes, my lord. After isolation, you would have the DNA, but after quantification, with qPCR, you would know how much DNA you have. That is correct.
For this purpose, 2 designated analysts are used to prepare this now for black or better terminology, a proper DNA sample, so that the genes can be mapped by the gene mapper.
My lord, so first a PCR is performed, and electrophoresis is done, and then the gene mapper software is deployed.
So
That's
but
how
for the PCR you have a new batch list,
Correct.
and this batch list in the PCR also includes 2 controls, a negative and a positive.
That's correct, my lord.
You found that in the paper trail that you asked.
That's correct, my lord.
This is then when you get to the, I hope I pronounce it correctly, the electrophoresis.
Electrophoresis, my lord. That is the next step indeed.
So that I can understand that I'm actually referring to the same thing that you have in mind, Dr. August. That is when we get that little page, the page with the peaks.
Yes, my lord.
That is the electrophoresis.
The electrophoresis, after electrophoresis, one gets this, what we call a trace or the peak, so the electropherogram.
And this, the peaks, the electropherogram, is the first time that you can actually now determine the profile of the person. Am I correct?
Correct.
This is the first time that there is usable information.
That's how I understand it, my lord.
And if I understand Colonel correctly, Dr. August, this whole process, as you have also set out in your exhibit EEE1, this whole process is continuously monitored in the laboratory by supervisors, including even CCTV.
Yes, my lord, that is how I recollect her testimony.
And it is this process that is determined by the SOPs.
Correct, my lord.
And then once the whole process has been completed, there is also what the FSL calls a peer review, a peer case review policy.
That would be logical.
Did you find the peer case review policy applied in the paper trail that you received?
My lord, I'll have to scan the SOPs, and I can do so tonight. But if the state is indicating that perhaps there are SOPs in our possession that's not here, that may be so, because we try to give a high-level overview. But I will verify that tonight.
Now, you've already alluded to the fact, Dr. Walters, that when you first engaged or started with your mandate, you requested the paper trail from the laboratory as well as the SOPs. They are two separate things, are they not?
My Lord, we requested, yes, the paper trail, the SOPs. We also asked the laboratory to indicate what system they use, what other standards they use, and they indicated they use the SOPs, the ISO guides, and they provided us with the paper trail documentation that we eventually received.
If I understand the request correctly, Dr. Orford, yes, there were two requests. The one said A, said B, and the second one said D and C. Your request was for all the samples, all the samples reported on by Colonel Otto in her 4 reports.
Correct. That's also our report.
Yeah. That is why you received 151 samples paper trail and not 216, 219 that were submitted.
Yes, my Lord, because we can only work with what is submitted to court. So we work with the 151.
So it's not like you asked for all 216 or 19 and only received 151.
My Lord, I only became aware that there were 216 analysed during the testimony of Colonel Otto. I initially thought that there was only 151 because that is what is in her report. However, it is possible that there could have been more, but I didn't know that for a fact. I only heard that the number was, I believe, 216 during her testimony.
But you are aware, because you are aware of during the process, during the course of the process, some samples might fall in the wayside. If you have regard to your 331, and you go to step number 5, DNA quantification with qPCR, you have a dual way of going, enough DNA or not enough DNA when the process is stopped.
My Lord, that is correct. So what we asked was the paper trail of the samples that the FSL submitted to court, so hence want the court to take into consideration. The samples that the FSL did not want the court to take into consideration, there would not have been a reason for us to look at that.
What I'm trying to get to, Dr. August, it's not like the lab is trying to hide some samples.
My Lord, I never alluded to that fact.
Now, case law that you refer to in your CV, Dr. August, is the status of Maquina, the 2001 judgment from Transvaal. That is where the court rules that the laboratory of FSL has to have a proper record keeping of the process that they follow, so that the process can be tested by experts such as yourself. Am I correct?
Sorry, which page is that, Ms. Gamble?
Lord, in the witness's CV,
My Lord, you,
Annex A01, it is paragraph page 25 of 33. The witness mentions the judgment in paragraph 18.1.5, status Makina and Mokukedi, heard in the Wetwatersrand Division, the High Court, first reported DNA case in South Africa.
my Lord, I also...
Is that the case before Judge van Wisden?
Yes. My Lord, I also refer to that same case in my report on page 4 of 10, where I quoted part of it, so the reference to the case is there.
So, am I correct, Dr. Walker, that is Why you were able to ask for the proper record keeping of the laboratory, because you will then be able to test the whole process, verify, audit it, as you say.
My Lord, if I have the paper trail, I can verify whether it is scientifically validated or not.
Am I correct, Dr. August, that the paper trail and the SOPs that you requested via council was handed to you directly by the laboratory before?
Yes, my Lord. It was handed directly. So I forget how the first set arrived at my office. I know it's a red set of files, and I believe those were sent to the instructing attorney's office, and I stand to be corrected. But the others were all the other data was collected by us at the FSL laboratory in Pretoria.
And you've already testified this, I'm just not sure if I remember your answer correctly, Dr. August, that you informed council what they needed to ask from the state and from the FSL regarding the paper trail and the SOPs.
My Lord, yes, I compiled a list which I forwarded to council, and then council most often would request all of that.
But did you ask generally or in this case?
In this case specifically.
In this case?
And in this case, council, I will have to verify, but I believe they requested what we asked from the state.
There was some email correspondence regarding the supply of the paper trail and the SOPs, Dr. August. Am I correct that I was also CC'd in those emails?
Yes, I don't know specific which emails the state refers to, but I do recall receiving some emails even from Advocate Breda that came directly or was CC'd to the state, my Lord.
And again, this is also something that you have answered. I'm sorry, I cannot relate your specific answer. Have you or have you not received everything that you asked for with regards to the paper trail? The SOP, you've said several times that you didn't receive the ones of non-conformance. Regarding the paper trail of the 151 samples, what you asked for, you got.
My Lord, I think I testified this morning, and I will have to just recall that I will go and verify tonight that it's categorically so. But to my recollection, it is.
And as far as my recollection goes, Dr. August, the red files that you referred to earlier also included the electrophoresis peaks of each of the samples.
The electropherograms of the samples, my Lord, and for convenience sake, perhaps we can refer to them as EPG. So electropherograms, the EPG acronym is what we
Much
use.
easier to pronounce than, and I will not mispronounce it again. EPGs.
At the time of the Makina case, there wasn't full, was there full discovery?
My Lord, we discovered what we could.
No, did the state discover everything? In the Makina case? The case you testified in?
I'm not sure what my Lordship means by did the state discover everything.
Did you get everything you wanted in that case?
My Lord, I will have to go and verify records. As far as I can recall, we were not hampered in that case by discovery. In a subsequent case,
I ask you that, Dr. Olkers, is this. At that time, there wasn't the full discovery system we have here. Since then, we've now got a constitutional court judgment that says defense is entitled to all the documents in the possession of the state.
If I may assist more, I will deal with the Makina judgment.
Oh, you'll deal with it, okay. Let me not jump the gun then.
But I will get there as to what was given to the defense and what the specific evidence in that case was.
My Lord,
Mr. Van Wisten was my lecturer.
My Lord, if I may clarify something, I am not aware of the Supreme Court of Appeals date
Sorry?
that my lordship was just referring to? About the discovery.
No, all I'm saying,
When in time that
Ms.
was?
Galloway will deal with it later. But what I was putting to you is that from the time that the Makina case was heard until now, the whole procedure has changed. You know, it's a matter of law entitled to full discovery, which was done in this case, as far as we know,
And-
as far as the court knows.
Yes, and the only thing I wanted to clarify was that I'm not aware or I'm not familiar with what date that changed.
Oh, it's just there's something in the 2000s. But do you know, Mr. Bertha?
Lord, I'm just Googling the Chabalala decision goes to support. My memory was the late 1990s.
The late
After
1990s?
the 1996 Constitution.
Well, what I do know is this. It came into operation after I stopped practice, which was in 1995. So if Mr. Bertha is correct, then it was just after the Makina case or just before.
Just before the Makina case was 2001 Makina case.
Oh, so then I'm totally wrong.
There were other problems in that.
Then I put it wrongly to you, Miss. If it's full discovery before that. Which was the date, Mr. Bertha?
It's only got a judgment, it's not the right one.
Yeah. In any case, it's a Sabolala decision which made it compulsory, in fact, to state to discover all the documents in their possession. But before that, I mean, you know, the situation was totally different.
Well, maybe at that point, I don't have to put one.
You want to adjourn at this stage?
I'm going over to a new point now, which might take.
Yeah. Can we just, before we adjourn, let me just say it's suited to the press. Sorry? Do you want to say something else?
Yes, Lord, I in fact managed to locate Chabalala, others was the Attorney General as well.
Yeah, that's the case.
It was heard on March 1995, and the judgment was in fact on the 29th of November 1995.
When was the judgment date?
November 1995. But the Lordship was indicating
Well, I was right.
As time goes on, we all seem to...
I was right. It came into operation 3 months after I became a judge. So I do a practice on this new liberal system of justice. Before we adjourn, we just indicate this particularly to the press and those who have, and to the queues, that tomorrow morning I propose to start at 9:30. And for the rest of this week, I'll start at 9:30 and not at 10. If it suits council, there's a problem, that's fine. But then tomorrow between 11 and 1, I'm not available and the case won't run. But we'll save the time in the mornings for the rest of the week and if necessary next week as well. Give us all good suit. Be early enough, you can start at 9:30 tomorrow morning. Thank you, this court is adjourned.